Meet Anna. She runs Green Bean Roasters Ltd, small artisan roastery, regular restaurant pints, always juggling cash flow and capacity. She hits a big trade fair to upgrade her kit before the Christmas rush. And to Sean, shiny stand, two options. Option 1 is right in front of her, a Roastmaster Pro 500, the exact display model bolted to the floor. Price tag, £30,000. Deal terms, ready for immediate delivery once the fair ends, payment due within 30 days of delivery. They shake on it, Sean's team will unbolt and pack and ship it next week. Option 2 is the Dream Machine, a custom Roastmaster Pro 700 with a larger hopper and special software. It'll be built in Italy, estimated 8 to 10 weeks. They agree in principle, and it emails confirmation after the fair and pays a 20% deposit to lock it in. Meanwhile, at a neighbouring stand, Anna buys ingredients. 100 kilograms of specialty beans from Chris. Those beans sit in a bonded warehouse as part of a 2-ton bulk, shipment number 22. Chris gives a receipt saying 100 kilograms allocated from shipment number 22, title to pass on payment. Anna pays on the spot. Timeline twist. Before the Pro 500 leaves the exhibition hall, an overnight fire breaks out and trashes the display machine. Sean says, property already passed the fair, your risk. Anna says, absolutely not. 6 weeks later, bad news from Italy. The factory building the Pro 700 goes bankrupt mid-build. The half-finished machine never ships. And at the warehouse, water damage hits shipment number 22 before anyone separates out Anna's 100 kilograms. Half the bulk is ruined. Breakdown time. 1. The Pro 500. It's a specific good, yes, but it wasn't in a deliverable state when they made the contract because Sean still had to unbolt and pack it. Under the Sale of Goods Act, property in specific goods passes when the goods are in a deliverable state and any required seller actions are done and the buyer has notice. No notice before the fire means property hadn't passed. Risk follows property in business sales, so the loss sits with Sean. 2. The Pro 700. That's a contract for future goods. It didn't exist when they agreed. Property can't pass until the goods exist and are ascertained or appropriated to the contract. A half-built machine that's never finished or earmarked for Anna doesn't give her ownership. Result, she has no proprietary claim to the unfinished kit and stands in line as an unsecured creditor to get her deposit back through contract and restitution routes. 3. The beans. Initially unascertained, part of a bulk, but modern law helps buyers here. If you've paid for a specified quantity from an identified bulk, you become a co-owner of that bulk in proportion to your share. She paid, the bulk is identified as shipment number 22, and her slice is 100 kilograms out of 2,000, 5%. When half the shipment is destroyed by water, she bears a proportional loss with the other co-owners. She can't demand the untouched half like a VIP lane. 4. Consumer versus business. Anna is acting in the course of business throughout, so we're in Sale of Goods Act territory, not the Consumer Rights Act. If she'd been buying a kitchen toy for home, consumer rules would push risk to pass on delivery. Different outcome potential on the Pro 500.